Some of the worst crimes ever known have been committed during the 20th century. Millions of children, women and men have been victims of unimaginable atrocities that have deeply shocked the conscience of humanity. Unfortunately, in the past, such crimes have often gone unpunished. Millions of people died during 2 world wars and in fighting in Rwanda, Sierra Leone and the former Yugoslavia. Although some of the highest military and political leaders accused of committing crimes during these conflicts have been prosecuted by temporary international courts, many crimes remain unpunished. The International Criminal Court is the first permanent court with jurisdiction over the most serious crimes threatening the peace, security and well-being of the world. In 1998, during the Rome Diplomatic Conference on the International Criminal Court, 160 countries negotiated a treaty to design the world's first permanent international criminal court. On the 17th of July 1998, after 5 weeks of intense negotiations, 120 nations voted in favour, and on July 1st, 2002, the Rome Statute entered into force after ratification by 60 countries. The court is located in The Hague, the Netherlands.
The ICC has been given jurisdiction over conducts which the international community have long accepted by a long tradition as amounting to the most serious crimes of concern to the international community as a whole. Those are crimes of genocide, crimes against humanity, war crimes, and as of the 17th of July 2018, the court also have jurisdiction over the crime of aggression under specific conditions. But the ICC is only a court of last resort. The reason for its creation is to ensure that there is no impunity for those who commit such crimes. It is important to stress that the primary responsibility to investigate, prosecute, and try those serious crimes remains with states. It is only when they fail to discharge that responsibility at all or genuinely that the ICC's jurisdiction kicks in. It is in that sense that the jurisdiction of the ICC is said to be complementary.
Since 2002, the court has developed into a professional institution with a 4-part structure. Although housed in the same building, the 4 organs of the court carry out distinctive mandates: the Presidency, Chambers, the Office of the Prosecutor and the Registry.
The presidency of the court is made up of 3 judges. They are the president and 2 vice presidents. The presidency manages the court, represents the court to the outside world, and helps to organize the work of the judges. The presidency is also responsible for carrying out other tasks, such as overseeing the carrying out of sentences that trial chambers impose on the persons found guilty of crimes within the jurisdiction of the court.
The court is composed of 18 judges who are elected for terms of office of 9 years by the Assembly of States Parties. The judges are chosen from among persons of high moral character, impartiality and integrity who possess the qualifications required in their respective states for appointment to the highest judicial offices. The election of the judges takes account of the need to represent the world's principal legal systems, a fair representation of men and women, and equitable geographical distribution.
The judges work together in formations called chambers. There are 3 levels of chambers at the court. They are the pre-trial chambers, the trial chambers, and the appeals chamber. There are 3 judges in a pre-trial chamber or a trial chamber and 5 in the appeals chamber.
I, Kimberly Prost, solemnly undertake
that I will perform my duties and exercise my powers as a judge of the International Criminal Court
honorably, faithfully, impartially, and conscientiously.
Et que je respecterai le caractère confidentiel des enquêtes et des poursuites
and the secrecy of the deliberations.
The registry is the biggest organ of the court. Its core functions are to provide administrative and operational support to the judiciary and to the office of the prosecutor. It also provides support concerning defence, victims, communications and security. It helps to service the court and develop effective mechanisms to assist victims, witnesses and the defence with a view to safeguarding their rights in accordance with the statute and the rules of procedure and evidence. The registry is headed by the registrar, who is the principal administrative officer of the court. The aim of the services provided by the registry is ultimately the conduct of fair, effective and expeditious public proceedings.
Beyond its activities at the court's HQ, the registry is in charge of field operations in support of investigations and prosecutions. It supports the work of counsel teams, both the defence and legal representatives of victims, as well as activities undertaken by the Trust Fund for Victims. In the field, the registry is responsible for ensuring the protection of witnesses, victims, and the effective participation of the latter. It's also involved in outreach activities with the affected communities.
The Office of the Prosecutor is independent from the other organs of the court. It is responsible for investigations into crimes and for the prosecution of those crimes in the courtroom. The mandate of the office is to conduct investigations and prosecutions of crimes that fall within the jurisdiction of the court. That is, the crime of genocide, crimes against humanity, and war crimes.
The procedural regime of the International Criminal Court is largely a combination of 2 different systems, common law and civil law systems. It always starts with the initiation of an investigation.
I, Fatou Bensouda, solemnly undertake
the prosecutor may start an investigation upon referral of a situation by a state party or the United Nations Security Council. I may decide to start an investigation on my own initiative on the territory or against nationals of a state party. In that case, I need to request authorization from the pretrial chamber. Before the commencement of a formal investigation, it is required to gather and assess relevant information in order to determine whether there is a reasonable basis to initiate an investigation.
The pre-trial judges take decisions that have to be taken in court before the trial begins. These include the decisions to authorize the prosecutor to initiate investigation into fresh cases, issue arrest warrants, and to confirm the charges or indictments, as they are called in some parts of the world, against the person suspected of a crime within the jurisdiction of the court.
Once the formal decision has been taken, the Office of the Prosecutor commences investigations in the areas where it is believed that the alleged crimes took place. In order to understand the situation and context in which crimes were allegedly committed, the investigators in the field interview witnesses and suspects and collect documents and materials which will enable them to determine the way in which crimes were committed and to identify those persons most responsible for the commission of such crimes.
When the investigators return from the field, all the evidence they've collected is thoroughly examined in order to piece together the chain of events and establish the criminal responsibility of those who designed the plans, gave the orders, or otherwise supervised or failed to prevent the commission of crimes.
It is a policy of the Office of the Prosecutor that investigations focus on those individuals who bear the greatest responsibility for the crimes committed in a situation under investigations. The application for a warrant of arrest and supporting material is then presented to the judges of the pretrial chamber.
It is in the authority of the pretrial chamber to grant or deny the office of the prosecutor leave to initiate an investigation. The pretrial chamber makes preliminary determination as to whether the situation in a country falls within the jurisdiction of the court. Confirmation of charges is one of the most important functions of the pretrial chamber. It involves a public hearing, and it takes place within a reasonable time after a suspect has been surrendered to the court or after the person has appeared voluntarily before the court. The pretrial chamber will confirm a charge against the suspect if there is enough evidence to believe that the person committed the crime in question. Confirmation of the charges does not mean that the pretrial chamber has found the person guilty. It only means that the pretrial chamber has decided that there is enough evidence to justify sending the person to be tried before the trial chamber. If there is insufficient evidence to justify sending a case to trial, then the pretrial chamber will not confirm the charge. The pretrial chambers also ensure that the prosecutor's investigations are done in ways that respect the rights of the suspect as well as the rights and interests of the victims and witnesses.
The court has no police or army to reinforce warrants of arrest, so it has to rely on the cooperation of states. It is the duty of the registrar to communicate a warrant of arrest to the state parties. When the state party receives a request for an arrest or surrender, it shall immediately take steps to arrest the person in question or inform the registrar that the person charged is available for surrender.
All rise, vous vous levez. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Vous vous asseoir.
There is hearing of the confirmation of charges brought by the prosecutor against Dominic Ongwen. The purpose is for the parties and for the participants to make their submissions on the question whether there is or there is not sufficient evidence to establish substantial grounds to believe that Dominic Ongwen committed each of the crimes with which he is charged by the prosecutor, and accordingly must be committed or not, or partly, to a trial chamber for trial on those charges.
If the charges are confirmed, the Presidency constitutes a trial chamber to try the case. The trial chamber's main task is to ensure a fair and expeditious trial, conducted with full respect for the rights of the accused and the protection of victims and witnesses. The trial is generally held in public. The chamber can, however, decide to exclude the public from some parts to protect confidential information or for reasons of victim and witness protection.
After the pre-trial chamber has confirmed the charge for trial, it is the judges of the trial chambers that actually conduct that trial in order to decide whether the accused persons are guilty of the crimes as charged or whether they remain innocent. It is important to remember that at the ICC, every accused person is presumed to be innocent unless they are found guilty at the end of their trial before the trial chamber. If the trial chamber finds him, that is the accused person, guilty, then the trial chamber will next decide on the punishment of the crime and on any reparation that may be made to the victims. It is a critical function of the trial chamber to ensure that the trial is both fair and not too long. And when we talk about fair trial, it is important to keep in mind that the trial chamber must ensure that every one concerned in the case is treated fairly. Although questions of fair trial concern the accused person mostly, it is also important to keep in mind that the trial chamber must also treat the prosecution fairly, as well as to ensure that the victims and witnesses are protected.
For the first time in the history of international criminal justice, victims have the right to participate in the proceedings and request reparations. This means that they may not only testify as witnesses, but may also present their views and concerns at all stages of the proceedings. It is most likely that they will do so through legal representatives. Victims can request various types of reparations, including restitution, compensation, or rehabilitation.
The trial chamber determines whether an accused is innocent or guilty of the charges, and if guilt has been determined, may impose a sentence of imprisonment not exceeding a maximum of 30 years, or in cases of extreme gravity, life imprisonment. Financial penalties may also be imposed. The trial chamber may order reparation to victims, including restitution, compensation, and rehabilitation.
The appeals chamber's job is to decide complaints made against either the pre-trial chamber or the trial chamber, saying that those other chambers made mistakes in a way that undermined their decisions. The aim of the person appealing is that the appeals chamber will overturn a particular decision made by a trial chamber or pre-trial chamber. When an appeal concerns the judgment of the trial chamber at the end of a trial, such an appeal may be by the prosecutor or by the defendant appealing his or her conviction or sentence or both. The 5 judges of the appeals chamber can confirm, reverse, or amend the decision or sentence or order a new trial before a different trial chamber. It may also revise the final judgment of conviction or sentence.
Persons detained under the authority of the International Criminal Court are kept in custody at the ICC detention centre, located within a Dutch prison complex in Scheveningen in The Hague. The detention centre functions to hold in safe, secure and humane custody those persons detained under the authority of the ICC, fulfilling the highest international standards. Whilst in the detention facility, the court has to ensure the mental, physical and spiritual welfare of detainees within an efficient system of detention. Detainees have rights that are guaranteed by various court rules and regulations. They are entitled to privacy with their defence lawyers, diplomatic states representatives, visits by their minister or spiritual advisor, as well as family members. They have access to fresh air, recreational time and sports activities, access to library and books, news, television, computers and medical care within the facility. Detainees are provided with food, but they can also cook themselves according to their taste and cultural requirements. Detainees are presumed innocent until proved guilty, so they're not sentenced and in jail, but awaiting trial. If they are sentenced, they will be transferred to a prison outside of the Netherlands, to a state that has voluntarily agreed to accept the prisoner. For the first time in the history of international criminal justice, victims have the right to participate in proceedings and request reparations. This means that they may not only testify as witnesses, but may also present their views and concerns at all stages of the proceedings.
To assist victims, the court has established within the registry the Victims' Participation and Reparations section and the Victims and Witnesses section. The VPRS assists victims in relation to their applications for participation in the proceedings and reparations. It also assists victims in obtaining legal advice and organising their legal representation. The Victims and Witnesses section provides protection and psychological support to victims who appear before the court as witnesses. This unit is also responsible for witness protection programs. The Office of Public Counsel for Victims provides support and assistance to the legal representatives of victims participating in the proceedings, as well as asking for reparations. It is also available to provide legal assistance to victims without charge. This is a new step in international criminal justice, which seeks to ensure the effective participation of victims before the court.
The court may order various types of reparation to victims, including compensation, restitution and rehabilitation. At the end of a trial, the trial chamber may decide to order a person convicted by the court to make reparations to victims of crimes for which he or she has been found guilty. The court may award reparations either on an individual or collective basis. The Assembly of State Parties established the Trust Fund for Victims in order to help implement reparation awards ordered against convicted persons. The Trust Fund for Victims forms an essential part of the International Criminal Court's innovative mandate towards victims and is an acknowledgement that justice for genocide, crimes against humanity and war crimes cannot be met by retribution alone. The Assembly of States Parties is the court's management oversight and legislative body, and is composed of representatives of the states which have ratified or acceded to the Rome Statute. The Assembly of States Parties has a bureau consisting of a president, 2 vice presidents, and 18 members elected by the Assembly for a 3-year term, taking into consideration equitable geographic distribution and adequate representation of the world's principal legal systems. It has a permanent secretariat at the seat of the court in The Hague. The Assembly of States Parties makes decisions on various issues, such as the adoption of normative texts and the budget, the election of the judges, and the election of the prosecutor and deputy prosecutors.
The court is a testament to the international community's commitment to put an end to impunity and to establish a new system of dealing with threats to international peace and security based on respect for justice and the rule of law. States, international organizations, and civil society have worked for years to develop such a system of international criminal justice. The evolution of that system goes back to the period immediately after the First World War. It took a firmer shape following the Second World War, as seen in the Nuremberg trials. The system came of age in the early 1990s with the establishment of ad hoc courts to try the atrocities committed during the breakup of the former Yugoslavia, as well as during the Rwandan genocide. The final act in that process of evolution was the adoption of the Rome Statute in 1998, according to which the ICC was created and organized. This system has come to stay. It is our responsibility collectively to ensure that the system remains effective and that it endures in that effectiveness.